In Arizona, the Court of General and Original Jurisdiction is the Arizona Superior Court. There are lots of courts in Arizona, but only the Arizona Superior Court can handle a broader range of cases at the initial level. In other words, there are some courts that are appellate; they can only hear cases on appeal. And there are other courts that are of limited jurisdiction. They can only handle specialized types of cases. But the Arizona Superior Court handles a broad array of cases. Civil and criminal are the two most common. They handle probate matters, family law matters, juvenile court matters, tax matters. If you're going to file a lawsuit and you don't know where to file it, as a general rule, it's going to be filed in the Arizona Superior Court. Now, there's some exceptions to that. But that's generally where you're going to file a lawsuit, Arizona Superior Court. In addition, even though normally you file a lawsuit in the Superior Court, you don't appeal to the Superior Court. There are some exceptions to that. In some cases, you're going to appeal to the Superior Court from a court of limited jurisdiction. But that's the exception rather than the rule. Don't file a lawsuit in the Superior Court if the lawsuit can be settled outside of court. If you've got a dispute, try to settle it if possible with the person you have the dispute with. In some cases, both parties will get attorneys, and the attorneys will talk on the phone, and they can resolve the dispute without the necessity of filing a lawsuit. But all too often I see situations where if people had just sat down and talked and avoided the necessity of filing a lawsuit, they could have saved them quite a bit of money. Sometimes you need to file the lawsuit to get the defendant to take the matter seriously until you actually sue them. They won't talk to you and negotiate really in good faith. Once you file the lawsuit, they actually listen to you. But try, if possible, to negotiate out your settlement either with or without attorneys prior to filing a lawsuit. If you file a lawsuit, the person filing the lawsuit is the plaintiff. There's no jurisdictional issues as far as jurisdiction over an individual is concerned when you file a lawsuit because you're agreeing to the jurisdiction of the court when you actually file it. The person that you're going to sue is called the defendant. And again, these are the general rules. Sometimes the person filing the lawsuit is a petitioner and the person who gets sued is a respondent. But in Arizona, in most cases, the person filing the lawsuit is the plaintiff. The person that gets sued is the defendant. The document the plaintiff files is called a complaint. And in the complaint, there's a bare bone allegation of facts that support the claim. If the defendant is out of state, the plaintiff can serve the defendant using Arizona's long-arm statute. As a general rule, the jurisdiction of a state, say Arizona, stops at the state border. But let's say you have a California resident that gets in an automobile accident in Arizona, they go back to California and you want to sue them. Well, with the Arizona long-arm statute, you can go ahead and have them served with an Arizona complaint and summons in California, and that would be a legitimate exercise of Arizona jurisdiction. Now, keep in mind, the premise behind the long-arm statute is that Arizona has jurisdiction over the defendant in the first place. So let's say you get into an accident with a California resident in California, and this California resident has no contacts, no minimum contacts with Arizona. They've never resided in Arizona. They've not visited Arizona. They don't have property in Arizona. They don't conduct business in Arizona. Under those circumstances, if the accident happened in California and you file a lawsuit in Arizona, the long-arm statute isn't going to do you any good because Arizona doesn't have any jurisdiction over this Californian in the first place because Arizona has no connections with the Californian. You're going to have to file the Californian in a California court or perhaps in the U.S. District Court. But since Arizona doesn't have jurisdiction over the defendant, the long-arm statute doesn't help you. The long-arm statute only helps you serve an out-of-state defendant when Arizona has jurisdiction in the first place. Once the defendant gets served with the complaint and summons, the defendant will have to file an answer. Now, if the defendant gets served and doesn't file answer, the general rule is the defendant's going to lose. Whatever not necessarily everything, but as a general rule, what the plaintiff has requested in the complaint will be more or less automatically, and it's not exactly automatic, but will be more or less automatically granted to the plaintiff. So if the plaintiff sues the defendant and says, I want $50,000, the defendant gets the complaint and ignores the complaint, doesn't go down and file a written answer, then the defendant simply loses the case. So if you ever get served with a lawsuit, don't ignore it. Ignoring it and then coming in later and saying, well, I didn't know what to do, or I couldn't afford an attorney or something like that, it isn't usually going to get the default set aside. There are some ways, if you file late, there are some ways and there's some circumstances you can have a default set aside. A default occurs when the defendant doesn't appear. But the ways to get a default set aside are limited. What you need to know is if you're sued, you've got, in the summons, will tell you how long you have to file an answer. It's usually 3 or 4 weeks. And if you fail to do so in that time period, with very few exceptions, you basically have just lost the lawsuit. And so file that answer. Here's a better rule. If you get sued, take the complaint and summons to an attorney. That's the best advice I can give you. Take the complaint and summons to an attorney. Sometimes the attorney can actually settle the lawsuit without filing an answer. Your attorney will call up the other attorney, they'll discuss it, they'll negotiate it, and they might be able to reach an agreement without an answer even being filed. So if you do get served, go talk to an attorney and don't wait. As soon as you get the papers, within 2 or 3 days, go talk to the attorney. You wait close to the deadline to talk to the attorney, you're probably going to pay a higher retainer. He may not want to take the case because attorneys don't like having to file an answer in the last moment if they can avoid it. Assuming that the defendant files an answer like he's supposed to, both parties have an obligation to disclose all relevant information concerning their case to the other party, whether requested or not. Now, this is the rule in Arizona. It's not the rule in most states, but it is here. It requires that the plaintiff and defendant, both parties, whether asked by the other party or not, have to disclose all relevant information to the other party. So you would have to disclose information even if it wasn't otherwise admissible in court. The idea is that if you're going to sue somebody or you're going to be sued, both parties have to show their whole deck of cards. They can't hold cards back. They need to disclose to the other party information they have, including information that's harmful to their case. For example, if there's an automobile accident and the plaintiff was injured, the plaintiff is going to have to disclose to the defendant any prior accidents they may have been in that might have caused injury to them. For example, if the plaintiff says, in the most recent accident, my back was hurt, the plaintiff is going to have to disclose prior accidents in which their back has been hurt, whether the defendant asked for that information or not. There are very few exceptions to this. The plaintiff both parties, plaintiff and defendant, have to disclose a factual basis for their claim, any legal theory they're going to use. So if either party is going to bring in cases or statutes to support their case, that information has to be disclosed to the other party. If the plaintiff is seeking damages, they're going to have to submit computation of damages. For example, a spreadsheet showing this is what the plaintiff wants. Plaintiff wants lost income from work and pain and suffering, medical expenses, and past medical expenses, future medical expenses. Whatever is sought by the plaintiff, that has to be disclosed to the defendant. There are a few exceptions. For example, confidential information between the attorney-client doesn't have to be disclosed, but that's going to be in a civil case. That's not going to come up too much. It could, but in most cases, any information that the attorney and the client talks about is already subject to disclosure. So while there's a confidence between what the client tells the attorney and that information is not subject to disclosure, much of the information is provided to the attorney is otherwise subject to the disclosure. So consequently, that exception is a rather narrow one. So if you're going to get involved in a civil lawsuit, be prepared to disclose information to the other side. It's a time-consuming, unpleasant process, frankly. Either before or after the lawsuit's filed, the parties may engage in mediation. Actually, mediation is mandated in most civil cases, and arbitration is mandated in many cases. In the case of mediation in Arizona, we call these settlement conferences. They're used a lot in civil cases in the Superior Court, and arbitration likewise is used quite a bit of times in the Superior Court. Mediation simply means the parties sit down with a mediator, who in some cases is a Superior Court judge or a pro tem Superior Court judge. I've done these many times as Superior Court pro tem judge. We get the attorneys, we get the parties together. Sometimes the parties, if they're out of state, will appear by conference call. There's lots of different ways we can do this, but we all sit down together and we discuss the case. It's the job of the mediator to try to get the parties to see reason and resolve the dispute without the necessity of a trial. I do these all the time, and I've had pretty good luck with these. Most of the cases I get, I settle, not all of them. And even in cases where you can't get the parties to agree on everything, sometimes you can get them to agree on some items so that when the case goes to trial, the jury doesn't have to deal with every conceivable issue. Some of the issues are resolved. For example, the defendant may acknowledge that he was at fault in the automobile accident, and that won't have to be tried. In that case, the only issue that will be tried is the question of how much money should the plaintiff get. So keep in mind that the mediator has no real power. The mediator tries to get the parties to settle, but if the parties don't want to settle, they don't settle. That's different from arbitration. In arbitration, the parties actually have a trial, usually before an attorney. The attorney acts like a judge. It's a trial. Witnesses are brought in. Exhibits are brought in. These arbitration hearings usually happen at the arbitrator attorney's office, or it could be the plaintiff's attorney's office or defendant attorney's office. So they don't take place down in the Superior Court. It's just a lawyer acting as a judge, but the hearing itself is pretty much like any other trial. There's no jury, obviously, but witnesses are brought in, attorneys, the witnesses are sworn, the opposing attorney can object to questions that are asked, exhibits are brought in and marked, and it's like a little trial. And most of these arbitration hearings, last an afternoon or maybe a day. And when the arbitration is over, the arbitrator will deliberate and, within a week or two, submit what's known as an award of arbitration. Is the award of arbitration appealable? It depends. In mandatory arbitration, they are appealable as what's known as a de novo trial, which means that the losing party can get a brand new trial before a Superior Court judge. If the arbitration is a result of an existing agreement that was an agreement that was made prior to the dispute, for example, an arbitration clause in a contract, typically those types of arbitration hearings are not appealable except under some very narrow circumstances. So if you get involved in arbitration, ask your attorney, is this appealable or is it not, and under what circumstances is it appealable? But I would say if we had to make a general rule, if it's court-ordered arbitration, it is appealable. If it's not court-ordered arbitration, it probably is not. Let's assume for a minute that the matter is not resolved by mediation or arbitration. The lawsuit proceeds, then it goes to trial. You can try a case either with or without a jury. If you have a jury, the jury determines the facts. The judge determines the law with the help of the attorneys. The judge gives the law provides the law to the jury in written instructions, And then the jury deliberates, determines the facts, and applies the facts to the law and reaches a decision. The jury in Arizona has a limited right to ask questions, and there's a procedure for that. Not every question they want asked is going to be asked, but if the jury's listening to the evidence and there's some information the jury wants, and they haven't heard the information, they can actually request that certain information be provided to them. We're one of the few states, if not the only state, that allows that. At trial, there are all sorts of rules of evidence. For example, you're probably familiar with the hearsay rule, which it's a complicated rule and it means a lot of things. But as a general rule, what hearsay means is that statements that are made in court for purposes of establishing the truth of the statements are not admissible unless the person that made the statement's there to testify about what he or she saw. So a person is a witness in a case, as a general proposition, is not allowed to testify about what somebody else told them. Now, it's a complex rule. There are many exceptions, but the idea is that we want the witnesses to have personal knowledge of what happened. We want a witness to the accident to testify as opposed to somebody the witness talked to. So if a person saw a traffic accident, they witnessed a traffic accident, and they told their friend about it, the friend's not going to be allowed to testify because the friend doesn't have any personal knowledge. All he knows is what his other friend, the witness, saw, and it's in his testimony would not be allowed. But there are many exceptions to the hearsay rule. It's a complicated rule. As a general rule, with many exceptions, with some exceptions, but as a general rule, the witnesses testify as to facts, not opinions. And so if you want to get up and testify as to what you observed, that's fine, but you typically are not going to be allowed to testify as to your opinion. For example, in some jurisdictions, you can, and this varies from jurisdiction to jurisdiction, but in some jurisdictions, you could testify that you saw a man walking, he was staggering, his speech was slurred, his eyes were dilated. You could testify to that. You could even testify that you smelled alcohol in his breath, but you couldn't testify that he was drunk. That's a conclusion that the jury would have to reach from the facts. Now, some jurisdictions will actually let you testify that the person was drunk. They make that as an exception. They say that's really not a question of opinion, that's a question of fact. So you get into these endless disputes in court as to what's a fact or what's an opinion. But the rule that I want you to know is that as a witness, you can testify as to your personal observations, but once you get away from your personal observations, then you may not be allowed to testify. The standard of proof in civil matters is preponderance of the evidence. What this means is that the party who will prevail, the plaintiff or defendant, will prevail if they can establish that they're more likely right and the other side is more likely wrong. It doesn't mean that the jury has to be 100% sure as to who's right or wrong. That never happens. Remember, trials aren't based on reality, they're based on what the evidence shows. So if you have a case where it's a medical malpractice case and the jury thinks, well, we think the doctor was probably careless. We think that he acted negligently. We're not sure, but we think he did. In that case, the doctor loses. Now, there's doubt in the jury's mind. They think that, the juries are saying, we think he acted negligently, but we're not sure of it. It's not clear to us from the facts for sure that he did it. We just think it's more likely that he's negligent than he was not negligent. In that case, a doctor loses, even though there may be a lot of room for doubt. Likewise, if the jury listens to the evidence and says, well, the doctor may have been negligent, but given all the facts, we're thinking probably he wasn't, then the doctor wins. As a defendant, he wins the case. Even though there's a good chance that maybe he was negligent, the jury's not sure, but they think it's more likely he wasn't at fault, he wins the case. So there's a lot of room for error in these cases, more so than there's just quite a bit of room for error. So when you run your business, be sure to document your transactions such that if there's a lawsuit, you can bring in evidence to convince a jury that you weren't at fault. When the case is over, if the plaintiff prevails, the plaintiff will get a judgment against the defendant. Keep in mind that it's the plaintiff's problem to collect that judgment. If you're filing a lawsuit against a defendant that doesn't have a lot of money, chances are you're not going to collect the judgment. You're going to have a hard time. The court clerk, the court personnel don't really take any steps to help you collect the judgment. It's up to you to go out and do the garnishments and attach assets and so forth. In most of these cases, unless you sued an insurance company or some a bank or some large corporation, they're just not going to pay the judgment. And so it's up to you to go out and try to collect it. If they don't pay it, if they don't pay it, you're going to have to garnish their checking account, garnish their wages, pick up some of their assets if you can, and it can be a tough job. As a general rule, if a person doesn't pay a judgment, they don't go to jail. I mean, in some cases like child support, they might, but in most cases, if you get a judgment against somebody and they don't pay it, you're going to have a tough time collecting. So as a consequence, if you do file a lawsuit against somebody, don't do it if you don't think you can collect the judgment after the lawsuit's over. For that reason, attorneys prefer to sue defendants when they know there's insurance in the background, because they know they can collect from the insurance company. If the losing side wants to appeal, they can appeal to the Court of Appeals. In Arizona, we have Division 1 and Division 2. Division 1 and Division 2 have jurisdiction over certain geographical areas. So if Division 1, which is in Phoenix, renders a decision, that's binding within their geographical area, which is northern Arizona. If Division 2 renders a decision, that's binding in their geographical area, which is southern Arizona. But their decisions are not binding in the other division's geographical area. The trial court, on the other hand, the Superior Court, their judgments are only binding on the parties. So when the Arizona Superior Court renders a decision, only the plaintiff and defendant is bound by that decision. Other people are not. But at the Court of Appeals level, when they reach a decision, as a general rule, everybody that lives within their districts, whether it's the district in the northern part of Arizona or the southern part, are bound by the Court of Appeals within that geographical area. As I said, Division 1 is in northern Arizona, Division 2 is in southern Arizona. As a general rule, if you lose at the Superior Court, you have a right to appeal to the Court of Appeals. The Court of Appeals is really only interested in looking for relatively serious mistakes by the trial court judge. The facts determined by the jury are usually not going to be changed by the Court of Appeals. They're not subject to review. So if you had 4 witnesses, 3 said the light was red, 1 said the light was green, and the jury decided to go along with the witness that said the light was green, you can't appeal and say, well, gee, you can't appeal to the Court of Appeals and say, well, gee, 3 of the witnesses said the light was red. The Court of Appeals is going to go, hey, that's a jury decision. They decided to disregard the testimony of the 3 people that said the light was red. They went with the testimony with the 1 person said the light was green. The Court of Appeals is not going to disturb that finding of fact by the jury in most cases. But if the judge makes relatively serious legal errors, keeps out critical evidence that should have been admitted, or makes a jury instruction that is wrong, and it's a particularly important jury instruction, then the Court of Appeals can either reverse the Superior Court, like they did in Lucy versus Emmer, or perhaps send the case back down for another trial. Now, if you lose to the Court of Appeal at the Court of Appeals level, you can take the case to the Supreme Court, but they have to agree to take the case. As a general rule, the Supreme Court, Arizona Supreme Court, will not hear your appeal. The loser at the Court of Appeals files a writ of certiorari at the Supreme Court. They review your request for the appeal, and in most cases, the Supreme Court will decide not to issue the writ of certiorari, which means that the decision at the Court of Appeals level stands. So the Supreme Court's pretty selective. I don't know what percentage of cases they take, but it's probably in the nature of 10 or 20% of the cases. They generally are more likely to take a criminal appeal than a civil appeal. So here's the general rule. If you lose at the Court of Appeals level, chances are that's as far as you're going to go. And by the way, you've already spent a lot of money just to get it through the Court of Appeals. You're probably out of money. You don't want to take it to the Supreme Court anyways. But in any case, if there's enough money involved and you want to take it to the Supreme Court, file a petition for writ of certiorari. If they take the case, great. If not, the case is over.